All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the North Carolina Court of Appeals. Your panel this morning consists of, to my right, Judge Allegra Collins, to my left, Judge Chris Freeman. My name is John Tyson. Our courtroom staff is here today. Our clerk and our marshal, Tom Salou, is with us. We have 3 cases on the docket for argument today. In re matter of foreclosure of the claim and lien on lot owned by Myers. So, counsel is present. Are there any preliminary matters that we should address before we begin? Okay, hearing none, we'll hear from the appellant. I wanted to kind of ask you, you're representing all parties, correct?
I represent the homeowners association.
Right. So, and counsel, you're representing the other? So you'll be addressing all issues on all 3 cases. Okay, great. Thank you very much. Okay, you may proceed.
Thank you. May it please the court. Ashley Oldfield on behalf of Smoky Mountain Country Club Property Owners Association. I'd like to reserve 5 minutes for rebuttal. Okay. The 3 cases before the court today are related, but each raise distinct legal and factual issues. And I want to start with the facts because, unfortunately, I think some of the briefing has muddied the waters as far as exactly what each case is about and what has happened in them. The association is the Homeowners Association for a Planned Community, and it's governed by a declaration and the Planned Community Act. And in the declaration is an agreement called the Clubhouse Dues Agreement, under which the declarant, SMCC, granted a perpetual, non-exclusive right to use the clubhouse to the association and the owners. And the owners agreed to pay clubhouse dues, and the association agreed to assess and collect those clubhouse dues and pay them to SMCC. And so that is what the clubhouse dues are. Now that agreement worked pretty well until 2014, when the association decided it was no longer going to collect clubhouse dues for payment to SMCC. And at that point, SMCC sued the association for breach of contract. And during that case, an appeal was taken to this court, and the court held that the declaration and the act authorized the association to assess clubhouse dues for payment to SMCC. And that's the Conley's Creek decision from 2017. So the case went back down for trial on the issues of breach and damages, and SMCC ended up with a judgment against the association for about $8 million. And that is the judgment. Now, under the Planned Community Act, judgments against an association may be assessed against the owners in proportion to their common expense liabilities. And that's Chapter 47F-3-115D.
And just so that I'm clear, the judgment is for the unpaid fees, correct?
Yes, past due and future dues is the way the jury calculated those damages back then. And that judgment is a final judgment. It was appealed, but the association dismissed the appeal before it was heard. So the judgment is final.
Give me the site again. It's 47F.
3-115D.
115D. And again, that statute provides
that when a judgment is rendered against an association, it can be assessed against the owners in proportion to their common expense liabilities. And what that
is that normally done on a per lot basis?
Yes.
Or per unit?
What that meant here was pro rata per lot, and what that worked out to was $48,120 per lot, and that's the $48,120 assessment.
Okay. When that was done, was there any difference between condominium units and individual lots?
No. The way the Planned Community Act defines lots, basically everything is a lot.
So a condominium owner was assessed the same amount as a person with a lot with a freestanding house on it?
Correct.
So it was based on ownership, not based on values or anything else?
That's right, Your Honor.
Okay, thank you.
And at this point, the association filed bankruptcy. And during the bankruptcy, it negotiated a plan of reorganization with SMCC, its primary creditor, in order to pay the judgment in installments over time. Now, the plan did not get rid of the judgment, and that is evident in several provisions of the plan, including Section 4.4.6, which provides that only after all of the payments are made pursuant to the plan does the judgment get marked satisfied. So the judgment is still there. And the way the installment payment plan worked was it was divided into 3 buckets. And the first was past due clubhouse dues. What hadn't been paid during the prior litigation was going to be assessed to the owners who hadn't paid, and they would pay, and that would be credited as payment on the judgment. The second bucket was future clubhouse dues. Essentially, the association was going to start assessing those dues again and collect them, and those would be paid on the judgment. And then the third bucket was a lump sum of $1.5 million to be paid over 3 years. And for that, the association was to assess each owner $9,200, and that's the $9,200 assessment. Now, there's a provision in the plan where if an owner doesn't pay the $9,200 assessment, they are deemed a delinquent owner. It's a defined term. And the right to receive the $9,200 assessment from delinquent owners could be assigned to SMCC. And that's the only provision in the plan that relates to assignment of the $9,200 assessment. But the bankruptcy plan in and of itself did not obligate any owner to pay the assessments under the installment payment plan. An owner's obligation to pay assessments arises under both the Declaration and the Planned Community Act. And so essentially, under the Declaration and the Act, the owners are obligated to pay their pro rata share of the judgment, which is the $48,120 assessment, but they have the option under the plan to pay their share in installments over time. Which finally brings us to the cases before the court today. The appellees here, the Myers, are owners in Smoky Mountain Country Club. They actually own 2 lots, the condo lot and lot 38. And they declined to pay the installment payments for either lot. And so the association sent them a statement of assessment in March of 2023 for the full amount, the $48,120 assessment. And they did not pay that either. The association then commenced a foreclosure proceeding against the condo lot to collect the $48,120 assessment. And in that proceeding, a hearing was held before the clerk. The clerk determined that the $48,120 assessment was valid, and she authorized the foreclosure sale to proceed. Myers appealed to the Superior Court for a de novo hearing. Meanwhile, the Myers also filed 2 lawsuits. The first was 23 CVS 24, which sought a declaratory judgment that the clubhouse dues agreement was invalid. That's the DJ action. And then the second was 23 CVS 176, which was an action to enjoin the foreclosure. And that's the injunction action. And they moved for summary judgment in the DJ action regarding the clubhouse dues and sought injunctive relief in the injunction action. All 3 of those matters were scheduled to be heard on the same day in March 2024. So now I'm going to try to take each of those cases in turn. In the foreclosure proceeding, the court dismissed that case for lack of standing. And that was error for 3 reasons. First, under the statutes governing non-judicial foreclosures, on appeal from a clerk's order, the Superior Court is required to conduct a de novo hearing. And the courts interpreting that, including the case in Ray Garvey, have been very clear. It's not a de novo review of what happened below, but a de novo hearing to determine the statutory criteria.
Can a court conduct a de novo hearing? Can the court conduct anything if it doesn't have subject matter jurisdiction?
Subject matter jurisdiction in special proceedings is conferred by statute, and whether a party, for example, has standing is something to be determined in the foreclosure proceeding, because that is part of the statutory criteria.
So the argument is that it could determine it didn't have subject matter jurisdiction, but it could only do so after a hearing. Or
Yes,
during the hearing.
Through the course of a de novo hearing, so that the association had the opportunity to present its evidence. And that de novo hearing never happened here. The judge in the transcript even said, I'm going to have to set aside a whole day for evidence. But he just never did that. Instead, 10 months went by, and then he entered the dismissal order. And that was error. A hearing is mandated by statute, and the Superior Court cannot just ignore a statutory mandate at its choosing. And then second, and I think this relates to what Judge Collins just asked, is the court doesn't have jurisdiction to determine standing absent that hearing. That hearing is where it determines the statutory criteria, which encompass standing. And so if there's no hearing, there's no subject matter jurisdiction to act outside of that.
During the interim between the I guess, the deferral, the trial court deferred any action, and then 10 months later entered a written order. Was there any communication or did your client have an opportunity to review that order before it was entered?
In January, shortly before the order was entered, the court asked us both to submit proposed orders, and both sides did submit proposed orders. And we also submitted a letter to the judge, which is in the record, basically saying we didn't think the court had jurisdiction to dismiss the foreclosure proceeding because he hadn't heard the case.
Well, you anticipated my next question. So you did raise the propriety of the action to enter the order absent the hearing?
Yes, so we sent the letter, and then we also sent our own proposed order denying the motion to dismiss because we hadn't had the hearing yet. And then third, the findings of fact in the dismissal order itself are not supported by the evidence, and the conclusions of law were not proper in light of that. First of all, since there was no de novo hearing held, no evidence was presented, and anything that was considered by the court was not properly before it, and therefore wouldn't have been competent evidence. Now, the court appeared to rely on the confirmation order from the association's bankruptcy case, but the confirmation order does not support the court's findings. What the court found was that the association was not the owner of the alleged debt because it had assigned the debt to SNCC via the confirmation order. But that is not what the confirmation order says. The alleged debt in the foreclosure proceeding was the $48,120 assessment. And there is nothing in the confirmation order about that assessment. The only provision in the confirmation order about assignment is assignment of the $9,200 assessment. And so the confirmation order just does not support the finding that the debt alleged in the foreclosure proceeding had been assigned.
So your point on the $48,000 is that goes back to the original lawsuit and the original finding. Is that correct?
Yes, that is the pro rata share of the judgment.
And so is it an either or? The property owner had a right to pay in installments under the bankruptcy order if it chose, but if not, they were still liable for the original $48,000. Is that your point?
That's right, Your Honor. They can't just get out of having to pay their share by saying they don't want to pay under the plan. They're still liable for the full amount of their pro rata share. They
And
have an option.
it's your argument, as I understand it, that when they did not pay according to the bankruptcy order, they were still liable under the original $48,000,
Yes,
and that your client was the proper person to assert that?
yes.
Okay.
Yes. And so for all of those reasons, the court erred by dismissing the foreclosure proceeding. Turning next.
Let me ask you one more thing before you leave there. Was there ever any dispute that the lot owners were subject to the declaration and subject to the lien that's under the Planned Community Act and under the declaration. Was there ever any challenge to that?
I mean, I believe that the Myers challenged those in these lawsuits.
But this has already been before this court, has it not? The validity of the declaration or not?
The validity of the clubhouse dues agreement, yes, was before the court in the Conleys Creek case. And in that case,
Were the Applees party, were they lot owners at that time?
no, the Myers and none of the owners were parties to that case.
But were they lot owners?
Oh, yes, yes.
So they didn't come in after the fact. They were owners at the time that judgment was, or that ruling from this court came down.
Yes, the Myers owned 2 lots. They bought one in, I believe, 2006 and the other in 2008, and the judgment was entered in 2019.
Am I also correct, the record reflects that their deeds for both of those properties reflected that the deeds were subject to the recorded declaration
That's right, Your Honor.
in both cases?
Yes, both deeds say that. Turning to the injunction action, this is the case where the Myers sought to enjoin the foreclosure proceeding. And at issue in the appeal are 2 stay orders entered by the court. The first was entered in March of 2024, shortly after the hearing, and it purported to stay the foreclosure proceeding. That's the first stay order. And then about 10 months later, the Myers filed a new motion, a motion to stay, and submitted a proposed order to the judge. Now, there was no hearing on that particular motion. The judge just entered, first it entered the dismissal order in the foreclosure proceeding, and then about 2 minutes later, the second stay order was entered, which again purported to stay the just dismissed foreclosure proceeding. And that's the second stay order. And both of those orders are error because the court did not have subject matter jurisdiction to enter either of them. And there's a few reasons for that. First, the legislature has provided the means by which a foreclosure sale can be halted. And that's through the filing of a separate action, like the injunction action. And in that separate action, the court can either enter an injunction or a TRO. And that is what the statute says. It's section 45-21.34. Now, when the legislature has already spoken on an issue, the court has no authority to act outside the terms of the legislative act. In other words, when the legislature says, here's what the court can do in this situation, the court has no authority to do something else. And what the statute authorizes here is an injunction, not a stay.
So do you contend that the Superior Court lacked the authority to enjoin a sale under 45-2134?
It could have entered an injunction. I do not dispute that fact. But what it did was enter a stay. And those are different things. The Myers say they're the same thing, but they're not. And we can assume that the legislature chose one and not the other for a reason. A stay operates on the judicial proceeding itself. In contrast, an injunction tells a person what to do or not to do. And that's what the statute provides for.
Is there any practical difference in this case between the two? I understand that different verbiage might be used.
I do think there is a practical difference because, first of all, an injunction would have been directed at the trustee. Tell the trustee you can't do this sale. The court really couldn't have even entered an injunction in this case because the trustee wasn't a party to it. And then also an injunction requires all of these different things in able to enter one. You know, findings, reasons for why the injunction is being entered, and also the statute requires a bond in the case of an injunction. The judge didn't do any of that here. He just entered a stay and stayed the case. And he did not have jurisdiction to do that.
And it's your argument that 45-2134 would preclude the court from entering a stay?
Correct.
Are you saying that's the exclusive remedy that the court would have to pause or to enjoin the foreclosure proceeding?
That's right. When the legislature has said, here's what you can do, there's no authority to do other things. And that's what the judge did here. And then there's two additional reasons those injunction or stay orders were improper. First, the second stay order was entered after the judge had left the district. And so he didn't have subject matter jurisdiction to do anything in the case at that point. The legislature, through the use of terms and sessions, has prescribed the time and place of the exercise of jurisdiction. And that's usually limited to district that the judge resides in or that he's been assigned to.
Was there any consent by the parties to have it entered out of term, out of session?
No. And a judge can't just go wherever they please in the state and start issuing orders. Now, there is an exception to that rule, which is that if the judge hears the motion properly while he has jurisdiction and then leaves and is out of term, out of session, out of district, he retains the jurisdiction to decide that motion. But that is not what happened here. The cases were venued and heard in District 43A by Judge Gavanis when he was assigned to that district in the spring of 2024. And that's when he entered the first stay order. But then his term ended, and he went back to his home district, which was District 40. And then 6 months later, in January, the Myers submitted a new motion to stay. That motion was never heard by the court. There was no hearing on it, and he just entered an order. So there was no jurisdiction for him to enter an order on a new motion that was never heard while he was assigned to District 43A. And then second is the timing of the second stay order. The foreclosure proceeding had already been dismissed at that point.
Was that dismissed when he was also out of session, or was that dismissed prior to that?
It was dismissed while he was out of session.
Okay, so did he have jurisdiction to do that in the first place?
I don't think he had subject
Okay,
matter.
so he didn't have subject matter jurisdiction to dismiss it, and then if he did he have subject matter to stay a dismissal because it had been dismissed? That's your argument, right? Either or?
Right, he couldn't stay it after it had been dismissed. The only thing left in the case at that point was
an appeal.
our potential appeal, and I don't think a court has any jurisdiction to stay an appeal.
Okay, my question is, what's the practical effect if these two stay orders were void? What's the practical effect on the other cases?
On the other cases? Well, at least theoretically, if the judge had stayed our right to appeal,
I'm saying if they're void, sort of, how does that relate to the outcome of the other cases here?
if the cases are remanded, reversed and remanded, and the stay orders are void, then we go back and carry on with the two cases.
Under the original foreclosure?
Yeah, we would proceed and get our de novo hearing in the foreclosure proceeding, and then the declaratory judgment action, depending on the court's ruling, would go forward.
And that would be an appeal from the clerk's order at that time?
Correct.
So you'd be right back before the judge on the hearing that you quote unquote never received.
Correct. And then turning to the third case, which is the declaratory judgment action. In this one, the court entered a summary judgment order declaring that under the Planned Community Act, the association is not authorized to collect clubhouse dues for payment to SMCC. And that order should be reversed for several reasons. First, the basis of its decision was its conclusion that in order for the Myers to be obligated to pay clubhouse dues, the agreement had to run with the land. And that's wrong as a matter of law, because the law of covenants running with the land only applies when there's no express agreement. That's the whole point of covenants running with the land, to make agreements enforceable on subsequent purchasers who weren't parties to the original agreement. So in other words, if the Myers independently agreed to pay clubhouse dues, then that agreement governs. And so whether or not the Myers had such an agreement is a question of material fact. Now, the court found that the plaintiffs did not sign such an agreement obligating them to pay clubhouse dues. That was finding of fact number 13. Now, keep in mind, this was a summary judgment at the summary judgment stage, which of course means that the court isn't supposed to be making findings of fact at all, because if there is a dispute as to a material fact, then summary judgment isn't proper.
Are you asserting summary judgment in your favor is proper, or just simply that there's a genuine issue that needs to go back?
To be frank, I do think summary judgment should have been awarded to us, but at a minimum, I think there is a dispute of material fact, because there was substantial evidence that the Myers did sign such an agreement, and that evidence that the association submitted was the agreement itself. When the Myers purchased the condo lot, they signed a contract, and the contract said that they agreed to be bound by the declaration and agreed that they would pay assessments levied by the association as described in the declaration, and that includes clubhouse dues. And they also admitted that they accepted their deeds subject to the declaration. So at a minimum, there is a dispute of material fact, which precludes summary judgment in favor of the Myers.
Generally, whether or not there's existence of a contract between the parties is a question of law, is it not?
Yes, Your Honor, yes.
So the existence or non-existence of contract, that's based on the writing.
Yes, yes.
So if that's true, then the court could decide that as a matter of law.
I mean, what the court said was that it did not, that the Myers did not sign such a document, and we had evidence of their signature on this document.
So that would be a disputed fact or not?
Right. I mean, it wasn't that he determined that the contract was valid or not valid. He just said they never even signed such a document, but we had evidence in the record that they did.
That's the original contract to purchase that made the contract subject to the recorded declaration, correct?
Correct. And there was a survival clause in that contract that said that these agreements survive the purchase. The other major error that the court made...
And again, when they accepted the deed, it was subject to the recorded declaration that contained that duty.
Correct. I see that I am into my rebuttal time. Are there any other questions before I sit down?
Well, before, any questions?
I'm good, thank you.
Any questions? You can reserve your closing then until your next time, right?
All right, thank you.
Okay, thank you. Hear from the appellee. Good morning.
Good morning, Your Honor. I would like to start with just a few facts. First of all, the original lien for the foreclosure was not for the $48,000. If Your Honors will look at the original lien that was filed that is within the record, it was approximately $15,000, and that included the $9,200 that is part of the confirmation plan and past due clubhouse dues. I would have to respectfully disagree that the confirmation plan did not do away with the judgment. There's multiple times in the confirmation plans that says it was a settlement and agreement to the judgment, that this is how it's going to pay. I have not seen in reviewing these, in reviewing the confirmation plans, any of the affidavits that have been submitted, and this is not the only case. Your Honors probably know I've been before this court not arguing, but there have been multiple cases where the HedgePest have tried to determine the validity of the clubhouse dues that have been promptly dismissed. So this has been an ongoing argument, and it was an ongoing argument even back in 2014 when the association was sued by SMCC Clubhouse. Specifically, if I can go back to the bankruptcy, in the bankruptcy, the confirmation plan said it was a settlement and agreement. There were 3 buckets, but it also assigned the debt collection to SMCC. That was a very big issue. They started with a confirmation plan, and then they went to an amended plan to make sure that the association was not tasked with the continued litigation of what it would do for the clubhouse dues. You also have in the record that the confirmation plan was also appealed, and it was appealed by myself, my husband, and 2 other homeowners by the name of Robert and Mary Young. And that order dismissing that appeal is also in the record for your honors to review. In that order, the appeal was dismissed for lack of standing of the Hedgepeths and Youngs because Judge Martin Ridinger said that whether or not that the homeowners were liable for anything, that was an open question that needed to be taken to the state court. That has been taken to the state court multiple times by the Hedgepeths and has been dismissed at 12B6, and now by the Myers, where we have prevailed under summary judgment.
Let me make sure I'm understanding your point.
Yes, sir.
Are you arguing that the clients or the parties here, the lot owners, are not subject to the declaration?
I'm not arguing that they're not subject to the declaration. Yes, they are. But they're subject to assessments that follow Chapter 47 and Chapter 55.
Okay, so just to be clear then, we're not arguing over whether or not your parties are subject to the declaration and the declaration contains the power to assess and also the power to lien. Is that correct?
They contain the power to assess valid assessments.
Okay, so we're not arguing over the power, we're arguing over the amount.
No, we're not even arguing, well, yes, I'm arguing over the power for the clubhouse dues because the clubhouse dues are not a valid assessment, and they're not valid for a couple of reasons. First of all, there is a clubhouse agreement. I can't argue that agreement because the Conley Creek opinion that was mentioned by the association says that the clubhouse agreement can be agreed to through Chapter 47 and the declaration. But if you look at that, it also was very clear, and if I can find that here, I'm going to do it from memory because it's harder to find than I'd wish, but it was very clear that the homeowners were not parties, and whether or not the homeowners owed clubhouse dues were not in question because they were not parties. And in fact, in that opinion,
the obligation to pay would arise under the declaration.
No, sir. Well, yes, sir. It's going to arise under the declaration, but it still has to be valid. Here's what we're here for.
Okay, I want to make sure the argument's clear. So, again, we're arguing about the amount that was assessed as opposed to the power to assess it.
Quite honestly, I think we're arguing about both specifically.
Okay, then my next question is, why didn't the 2017 appeal, why wouldn't that judicially stop any argument concerning the validity of the declaration or the power of the homeowner association to assess?
It gave them the power to assess clubhouse dues, but it did not say whether or not it was a valid fee. That was recognized by this court because this court specifically said that the homeowners were not a party and whether or not they owed it, whether or not it was owed was not being assessed. The only thing that they were looking at was whether or not a homeowners association can make a contract in the declaration, and is that allowable by Chapter 47? That was the only question the 2017 opinion did. And it said, yeah, you can make a contract. And I'm not here disputing that the homeowners association could make a contract to assess, bill, and collect.
Now, the unit owners also, by virtue of the declaration, are members of the homeowner association, correct?
They are.
And they also elect the board of directors and officers of the homeowner association.
That would be a question that has gone on with this association as to whether or not they are being allowed to vote. That has been brought up, but it's not part of this litigation.
But under the statute,
Under the statute.
under PCA, that's that's the rights and duties of the lot owners to elect the HOA and to be part of the HOA.
That would be a right that they should have, Your Honor.
And
Whether-
the HOA would act on behalf of and with the power of the lot owners.
Well, you would think that would be true, but the HOA in this case received the order dismissing the appeals of the Hedgepeths and the Myers, saying that there was an open question as to the validity of these clubhouse dues. And instead of coming to the court and determine if it was valid, they filed lien on 14 homeowners and foreclosures on 1.
Do you agree that the bankruptcy order provided an installment option for the homeowners to pay?
There was an installment, but it wasn't an option.
So that was, your argument, as I understand it, then, is that supplanted the $48,000 assessment.
That is correct. And if you look at the record, there's only one reason that they filed a claim of lien for $15,000. Their claim of lien was for that portion that was due at that time. When the Myers stood up and said, there's a question as to whether or not these fees are valid, Judge Ridinger said so, they went, oh, if you're not going to pay $15,000, we'll do the foreclosure for $48,000. They never updated or refiled. You can't update a lien, but they never filed another lien and foreclosed on a lien of $48,000. Their lien in 22M, it was filed in 22, and I think it was M35, was for $15,000, but their foreclosure was the full amount of the judgment. And their reasoning was that since they wouldn't pay the $15,000 that was due at that time, they just go ahead and do the entire judgment, that they had the option to do that. The Myers or any homeowner was never given the option to do this or that. They started receiving invoices for clubhouse dues and the $9,200 from the confirmation plan prior to the confirmation plan being ordered by the court.
Can you give me the bottom line argument?
Bottom line argument is just going to...
Did the Myers owe, is there any valid debt here? Did the Myers owe? So is that sort of the bottom line?
The bottom line is, what we have here is we have a developer who set up a clubhouse. The Homeowners Association does not own any part of the clubhouse. And in fact, in the record, you have in the record testimony from the 2019 where the developer says that it was set up because he needed a return, an 8% interest on return of his $1.6 million judgment, and that he needed the homeowners to assess that fee because he knew he couldn't collect it. But the Homeowners Association had the power of foreclosure. So that's what the argument is. Can a homeowners association assess, bill, and collect, send 100% of that fee? They don't even get money for the cost of collection. They send 100% of that fee, and then if the Myers or someone questions it, even though they signed a confirmation plan that they would turn the delinquent owners over to SMCC, the developer, now they're foreclosing. So that's why we're here today, because if this case goes through, we are now allowing every homeowner association in the state of North Carolina to assess, bill, and collect for for-profit corporations. And that's what's going on. Now, if you read the transcript, and I'm going to bring that up for two reasons.
Is this ownership that unusual that the developer would keep amenities and that the lot owners would pay an annual or monthly fee toward those?
Yes, it is. If you go back to Mid-South Golf, this case has come before this court before. And in fact, in the Conley's Creek opinion that we've mentioned here today, Mid-South Gulf has been used in that. And the reason Mid-South Gulf didn't apply in Conley's Creek, because they weren't looking at the duty of the homeowner to pay. They were only looking at the agreement between the homeowners association and the developer to assess, bill, and collect.
Well, is it your position that the homeowners can use the common areas and facilities free?
This is not common area. If it were a common area, I would not have a case here, Your Honor. The common area, there's ownership of the HOA. This is not a common area. It's owned by SMCC Clubhouse. They maintain it. Not only do they own it, they allow people outside the community to come in and use it. It is not behind the gates of the community. It is totally separate. Totally separate. So if SMCC wanted to fix this and take my argument away, whether there was a judgment or whether we're looking at the 1999 amended covenants, the argument would have been, here's 10% ownership HOA, and it takes my argument away, because now they do have that ownership, which meets Mid-South Gulf. And Mid-South Gulf said it had to run with the land, it had to touch and concern the land for it to be a requirement. And that's not what we have here, all right? So your original judgment was based on past clubhouse dues, present clubhouse dues, and future clubhouse dues to 2047. That's how we got $8 million. And then when they went to the Court of Appeals, and I'll strike that, then they went to bankruptcy, they did away with the judgment and reverted back to the 1999 amended covenants. And if you read Judge Martin Reidinger's order, that is exactly what he says, is this confirmation plan does not require the homeowners like the Myers to pay. The confirmation plan reverts back to the 1999 amended covenants. And whether or not those covenants are valid is an open question for the state court, which at that time, the Hedgepaths had already filed before the confirmation plan trying to determine, and it was dismissed.
So when we look at the bankruptcy order, is your position that that order did vacate or void the $8 million judgment?
It says, yes, it does. It says in there, settlement and agreement, it says the debtor is not deemed to be in default under the obligations to SMC for non-payment of delinquent assessments by delinquent owners, which are assigned the SMC, and SMC Clubhouse shall bear the sole risk of collecting. If you go in and you search the order for settlement, on page 25 of 34, compromise and settlement pursuant to bankruptcy 919 and in consideration of the distributions. And it goes on, and it says that the judgment is compromised and settled. So there's nothing in here that says you either pay your pro rata share of the debt or you pay the clubhouse dues. It went back to it reverted back to the 1999 amended covenants, which falls then under Mid-South Gulf.
Were all the individual lot owners parties to the bankruptcy?
All the individual lots owners are party to the bankruptcy, and they filed.
Or is it just the homeowners association?
No, strike that. The homeowners association was parties, but the homeowners filed many motions trying to get this stopped because they did not agree with what the board was doing. Myers being one of them and the Hedgepaths being another. And thus the reason there was an appeal, because it was a consent judgment. And part of the consent was there was an appeal in this court. And as part of the consent, this board went up there and just said, oh, we'll consent to everything. Oh, and let's just dismiss the appeal. So there's parts of the case I would love for this court to hear that's not before you today. But because of the things that have occurred, the clubhouse dues under the 1999 amended covenants, we need to determine for the entire state whether or not a for-profit corporation such as SMCC Clubhouse can have a homeowners association. This court has ruled they can have a contract for that to happen. But just because they assess and bill and collect it, does that fall under Chapter 47 and Chapter 55? If it does, we're making new law here today. And I can tell you there's already been a case in Charlotte that I've been following that is the exact same thing that's probably going to get up to this court. So
Can you explain to me 25701, the declaratory judgment action? What happened in that case, and what are you arguing here?
I'm so sorry.
I'm sorry, could you hear me? No?
I heard a little bit. But
Yep. So 25701 is the declaratory judgment case here. What happened in that case, and what are you arguing?
In that case, on March the 11th, in that day, there were 3 cases. And I would ask, and I'm going to get back to your question, I just don't want to forget. I would ask the argument they didn't have a trial de novo. If you look at the transcripts they did.
That's the foreclosure appeal, right?
That's a foreclosure.
Okay.
If you look at the transcripts, the trial de novo actually started in the transcript for 2324.
But let's just go to the declaratory judgment.
Okay. In the declaratory judgment, their argument is summary judgment was not proper. But it was, because just as she stood here today and said that if summary judgment had gone on their end, there wouldn't be a question of fact. The complaint was verified. It had multiple exhibits that were verified.
What did that declaratory judgment decide? What did it declare?
It declared that the clubhouse dues were not a valid fee because they did not touch and concern the land following Mid-South Gulf. All right? So there's no contract, and I'll come back to that, anywhere that the Myers or anybody else has said, I'm going to pay clubhouse dues. What the contract that they tried to get it through said was that they would be assessed clubhouse dues through the association. But the association has to have the ability to assess a valid fee. So the order specifically for the declaratory judgment specifically follows that you have a homeowners association bound by Chapter 47. You have a corporate entity, SMCC Clubhouse, which was Conley Creek at the time it came before this court. Conley Creek assigned to SMCC. They're for-profit, and they are receiving every single penny of that assessment. So there's absolutely no benefit. There's no opt-out. If I'm an owner and I'm a retired individual and I'm handicapped and I don't want to use the pool or the tennis courts or the fitness center that's half burnt down, I still have to do it. It doesn't matter. All right, I have to pay that fee. All right, there's no opt-out. But then your corporate, who owns it, they can have people come in and make more money because they are in total control. Chapter 47 does not allow that to happen.
How does the declaratory judgment action relate to the foreclosure appeal? Meaning, if you win on the declaratory judgment action, what's the result of the foreclosure?
Well, Judge Gavanis asked each one of us to brief. And there were briefs submitted. They are part of the record. And when you go back and brief, the judgment is the clubhouse dues. The judgment was determined by past clubhouse dues without any regard to a statute of limitation. That if you owed PAC to 2011, you were going to pay it by this judgment. So that was part of the judgment. The present clubhouse dues and future dues to 2047. So if the clubhouse dues are an invalid fee, they have no judgment to settle and compromise in the confirmation plan. It is a cycle. It is just a cycle. As Judge Gavanis said in his transcript, and it's a shell game. We go from one thing to the other. Today, it's the 1990 Amendment Covenant, but now we're going to get an order that says we got to pay the clubhouse dues. So it don't matter if they're not valid or not because we have a judgment. And that's what we're going back and forth on. So without the clubhouse dues, there is not a foreclosure. For $48,000, which quite honestly, I haven't seen law to support that I can file a claim on lien for one thing, and then by the time I file foreclosure, I just put a whole nother number on there. And that's what we have here. So if I go with the claim on lien that they originally filed at $15,000 and some change, that would be the clubhouse dues, the $9,200 for the attorney fees to get that judgment, all right, and the past due and present, and that $9,200. Or if I go over here to where they decided to foreclose on the pro rata share of the judgment, it's all clubhouse dues.
So is it your contention now essentially this case should go away and it's now the homeowners association's burden to file a declaratory judgment to determine whether they are in fact allowed to assess these dues?
They should. They should have when they received the order in March of 2021, I believe, 2021 from Judge Ridinger. When they saw that, they should have filed. The Myers shouldn't have had to pay to file it. They should have filed. That's their duty. And in fact, I had appealed because the breach of fiduciary duty was dismissed while this is on appeal. The breach of fiduciary duty was dismissed in this case, and this court upheld that. I think the homeowners association has a duty to determine, all right? But their duty, their agreement is to assess, bill, and collect, and to pay. And if you look at the confirmation here, order, it is specific. They pay what they collect. Pay what they collect. So they bill it, assess, bill, collect it. They pay what they collect. If someone doesn't pay, they are to give that information to SMCC Clubhouse for them to bear the sole cost.
Who is paying for the maintenance of the facilities there?
SMCC Clubhouse.
So the owners are not paying for that.
No, sir.
So,
They are for
are the lot owners free to use those amenities as they see fit?
only if they are current on their clubhouse dues.
Okay, is that abnormal for any type of planned community that you've got to pay your
Yes and
fees?
no. I've seen it both ways. I represent a lot of HOAs, and a lot of them will suspend privileges as if they're not current, but there's no suspension of privileges here. It's just you can't use the clubhouse. So if they're not current on their clubhouse dues, any other common area they can use. They just can't use what's owned by SMCC.
But anytime you're in a planned community, the residents are free to use the amenities that are offered or not use them. The fact they choose not to use them or can't use them because of some liability that does not excuse them from paying the dues, correct?
That would be correct if the HOA has any type of ownership in those amenities.
Well,
But this one
you're,
has
you're saying that in order for the HOA to enforce the dues requirement, it has to own them. But this court's prior case in 2017 specifically addressed that issue.
But no, sir, it did not.
It
what-
upheld the validity of the dues agreement.
But the agreement was not between the owners and the agreement was between the association. And if you go back and read that, Conley's Creek, it is very, very exact that they are looking at the agreement, not whether or not it's be paid. That they
Do
can
you
assess
agree that the
uncollected.
HOA is the agent of the owners?
Not in this case, no, sir, I do not.
Isn't that generally true?
It's supposed to be true, but do I believe it in this case? Absolutely not. They had a duty to come to this court and determine if those were valid fees, and they did not. They chose not to. There's a reason why. And what has occurred since Conley Creek, there was one narrow opinion, and that opinion has been used by the developer to say it's an enforceable contract. The only thing this court has determined that's an enforceable contract is between SMCC and the association. And the association affirmed it without the owners in the confirmation plan that they would assess, bill, and collect what they collected and turn the delinquency over to SMCC. They haven't done that either because they filed for foreclosure. They should have never filed for foreclosure. It should have been turned over to SMCC. But it goes back to Conley Creek's order, and it goes back to Judge Ridinger's order, and he applied Travelers when he dismissed it because in the Travelers case, they were the confirmation plan did not directly affect the amount that was owed. It was one step away. That is exactly what Judge Ridinger said. This confirmation plan, taking it back to the 1999 amended covenants, it's never been decided whether or not the homeowners owe. This is an open question for your honors today. And that's what we're asking you to determine. Does a for-profit corporation have the right to own something and require homeowners to be a member under Chapter 47 without no ownership, no say, or anything? And if they do, can you go all the way to 2047 and find somebody liable for that?
I'll give you a moment to sum up then.
Okay. Your Honor, I think it's very clear. I mean, we need to look at whether or not what can be done in a homeowners association. There's a reason why a homeowners association is a non-profit. They cannot be billing $1.6 million at 8% interest so that the developer can pad his pockets. And I would ask your honors that you uphold the dismissal of the foreclosure. It was vetted, brief-wise, affidavit-wise, argument-wise, and I would also ask that you enter a declaratory judgment upholding that the clubhouse dues are invalid. Thank you, Your Honor.
Thank you. Any questions?
No, I'm good, thank you.
Thank you. Rebuttal?
Thank you. Just have two issues that I wanted to address.
Let me go back and ask one question to clear up a matter. Counsel has said that there was a hearing prior to the entry of the order, and you've argued there was no hearing whatsoever, and the statute requires a hearing. Is that correct?
Yes, so...
Would you address that specific issue?
Sure. So all three matters were set for hearing in March 2024. In the morning, we had a hearing in the injunction action and the declaratory judgment action. And then in the afternoon, the court called on for hearing the foreclosure proceeding. and it addressed several motions that the Meyers had filed. And the court, at the end of that, hearing those motions, it struck all of the motions as being improper. And then immediately it said, I'm staying this case. I'm going to have a whole day for evidence. And so we never got to the de novo evidentiary hearing. All that was heard were the motions that were struck.
And then the court specifically held over the other matter and saying there's a hearing. Is that what the transcript will reflect?
In the foreclosure proceeding, it said it was staying the foreclosure proceeding, and he certainly seemed to suggest that he intended to hold a hearing later. It's just, it never happened.
Thank you.
The big issue is this, in the summary judgment order, is the court said that the Planned Community Act and the declaration do not authorize the association to assess clubhouse dues for payment to SMCC. And the Conley's Creek case says, yes, it does. And the issue that was raised by the Meyers and by the court is that the association does not own the clubhouse. It's not a common element. And we concede that point. That is not in dispute. It is not a common element owned by the association. But that is the exact issue that was raised in Conley's Creek. Their argument in that case was that the association can't assess dues for something that is not a common element. And the court said, no, it rejected that argument. And in reaching the decision, the court looked at both the declaration and the Planned Community Act. And it said, first, it's the declaration of a community that provides its legal authority so long as it's not in conflict with the act. And it looked at the declaration here and it said, one, the declaration does authorize this assessment, and two, the Planned Community Act doesn't prohibit it. So it is an authorized assessment. And then the court looked at the Planned Community Act itself, specifically section 47F-3-102, subsection 10. And the court said that even though the clubhouse isn't a common element, the act nonetheless authorizes the collection of clubhouse dues for payment to SMCC because it authorizes an association to assess dues for services, including, quote, the developer's role of providing access to and maintaining a clubhouse amenity. And so this court has already decided, yes, the association is authorized to make this assessment and collect it. And it's like any other assessment where an HOA contracts with a third party, let's say a landscaping company or a trash collector, to provide services to the HOA. It assesses its members for those costs, and it pays those costs to the third party for-profit entity. And that is what is happening here. The developer is providing an amenity. That is a service. And that is what the association is assessing for.
So your argument is that that issue is foreclosed by the court's prior opinion in 17.
Correct. And the summary judgment order basically just totally ignores that and comes to the opposite conclusion.
Do you feel like the HOA is an agent of the owners?
All of the owners are members of it, and so yes, it represents the owners' interests.
Is there a difference between being an agent of the owners and the fact that all of the owners are members of it? Because you parsed your words there.
That's right. I had not considered that question before, so I'm not sure if there is a difference between the two.
Because the argument here is that the homeowners association is not acting on behalf of the homeowners.
I don't really understand that argument. I think there are some underlying things that are not in the record that they are complaining about and have some feelings about the way that the association is operating, but those aren't really part of this case.
There was a mention of a prior challenge on a breach of fiduciary duty of the HOA. Is that in our record?
So that is in the declaratory judgment action. In addition to the claim for a declaratory judgment, the Meyers also asserted about a half dozen other claims against the association.
And those were the ones that were dismissed?
They were dismissed. The Myers did appeal from that, and that appeal was dismissed.
By this court?
Yes.
I'll give you a moment to sum up if you need it.
What we were asking for is that the dismissal order in the foreclosure proceeding be reversed and the case remanded so that we can go back and have our de novo hearing and have the opportunity to present our evidence. We ask that the stay orders and the injunction action be vacated, and then in the declaratory judgment action, that the summary judgment order be reversed.
And I do have one final question. I want to go back to your comment on whether the bankruptcy order supplanted the $48,000 with the $9,200.
Right, thank you, Your Honor. So in the plan, first of all, we do not agree with that statement. In the plan, it says, and this is section 4.4.6 of the plan, it says that as long as the association fulfills its obligations under the plan, execution on the judgment is stayed. But if the association does not fulfill its obligations, then SMCC can execute on the judgment. And so that is...
So the original judgment in your argument was never set aside or supplanted by the bankruptcy court order? Is that a fair?
Yes, that's correct.
So how can, if it's SMCC's duty, then how can the homeowners association follow up with the foreclosure? It seems like there's a dividing line there.
So the only provision in the plan about assigning any collection to SMCC is for the $9,200 assessment. And it said that the association could assign that for the delinquent owners. There was not any evidence in the record that that assignment actually occurred, and it was not for all of the judgment. It was specifically for the $9,200 assessment for delinquent owners.
So you were saying that it seems like that you're arguing the flip version, which is the homeowners association was allowed to assign it, but isn't SMCC's duty to do the assigning or not? Or am I incorrect there?
I think you're incorrect on that, Your Honor. So the judgment is what the association owes to SMCC. The plan set up an option for how they could get that money and then pay it to SMCC. And the appeal to the federal district court that counsel mentioned was dismissed because the court said those parties did not have standing to appeal because the plan didn't obligate the owners to do anything. It was just, they could pay under the plan, but it wasn't an obligation to pay. And then the plan does provide that the association can assign the right to receive the $9,200 assessment from delinquent owners to SMCC. Does that answer your question?
Very clearly. Thank you.
Thank you.
Thank you.
The case is submitted. We thank the parties for their good arguments and their briefing. And there's nothing further to come before the court. We'll ask that the court be adjourned.
All rise. Have a good day. You're welcome. This session of the North Carolina Court of Appeals is now adjourned.